Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. If you don't know, the election is 1 month away. This week, Immigrants List reported that in addition to the human toll, would-be President-again Donald Trump's mass deportation plan of millions and millions of people would cost American taxpayers $265 billion. In addition to that, for every 1 million immigrant workers lost, the data shows, it's estimated that 88,000 jobs held by native-born American workers will also be lost, totaling an estimated 986,000 jobs if you deport 11 million people. Immigrants List also reports that the current immigration workforce that Mr. Trump isn't so fond of, if permitted to stay, will reduce the deficit by almost $1 trillion and will increase GDP by over $7 trillion in the next decade. And that's according actually to the Congressional Budget Office. These workers in large part will not replace U.S. workers, they will increase them. And you can find the data that underlies these figures on the Immigrants List website. And I guess also the website for the Congressional Budget Office. Also, and if you have the desire, of course, search for and check out the Next Lawyer Up podcast. It's hosted by Alabama attorney Ron Sixtus, and well, it's not immigration related at all, really. Quote, it's a podcast where lawyers talk about lawyering and how they got to where they are and what they do. It features a number of prominent lawyers throughout the United States, end quote. It also recently featured me, making that episode a serious outlier in an otherwise stellar and respectable show. I was put in touch with Ron by San Diego immigration judge Rico Bartolome, who was a JAG attorney with Ron way back when, and now, well, is a bit of a podcast matchmaker. So give that episode and all his other episodes a listen. And thanks again for the invite, Ron. It's always a pleasure to speak to other podcasters. Links in the show notes. First up is Nguyen v. Jaddou, published by the Fifth Circuit on October 3rd, 2024. This case is about EB-3 visas. These almost never happen on the pod. So I'm going to do it first, even though it's a non-citizen loss, before the monster non-citizen win from the Ninth Circuit. And here we go. Quote, an EB-3 visa permits non-citizens 1, who performed unskilled labor, and 2, have a full-time job offer to work in the United States. If a non-citizen worker is issued an EB-3 visa, he is eligible for adjustment of status to permanent resident, end quote, under INA Section 245A. It's a 3-step process, outlined by the Fifth Circuit here. First, a prospective employer must file a labor certification with the Department of Labor. What is a labor cert? Well, it's the Department of Labor telling USCIS that there are, quote, not sufficient U.S. workers able, willing, qualified, and available, end quote, to do the job. and that the, quote, employment of the foreign worker will not adversely affect the wages and working conditions of similarly employed U.S. workers, end quote. For all of those concerned about non-citizens taking U.S. jobs. That all takes quite a bit of time and effort, but if the Department of Labor issues the labor cert, quote, the employer can petition USCIS for an EB-3 visa on behalf of the non-citizen worker by filing a Form I-140 petition, end quote. That's step 2. The I-140 must include evidence that the employer can pay the non-citizen worker's proffered wage from the priority date until he obtains lawful permanent resident status. Kinda like an I-130 and proving a valid marriage, except it's an I-140 and it's proving valid potential employment, and you have to do it for a longer period of time. Serves the same role though. Step 3, adjustment of status under the same General Adjustment of Status statute, INA Section 245A. Here the entity petitioning for Mr. Nguyen is Muy Pizza, and Muy Pizza obtained a labor cert for Mr. Nguyen. Unsure what Mr. Nguyen was going to do for the pizza place, but the Department of Labor said that there weren't sufficient U.S. workers to do it. That allowed Muy Pizza to file an I-140 petition for Mr. Nguyen, kind of like how U.S. citizen spouses file an I-130 petition for their non-citizen spouse. Looks like Mr. Nguyen and his derivative family members then filed to adjust to LPR status while the I-140 was pending, as they were in the United States lawfully, and as the law allows, that is, concurrent filings. But while it was all pending, 2 years later, Muy Pizza sold the restaurant that employed Mr. Nguyen to their arch-enemy, I-140 Pizza. Now I'm just kidding. I know very little about local pizza rivalries. But not nothing. And I-140 continued to employ Mr. Nguyen. USCIS then approved the I-140 petition, but then USCIS issued a notice to revoke the approval, explaining that, quote, an article reporting that Muy Companies sold several of its locations raised questions about Muy Pizza's intention to employ Mr. Nguyen, end quote, or pay his wages. Hard to argue against that, right? They no longer employed him. Also, seems like Muy Pizza filed I-140s for a whole bunch of pizza people. I-140 Pizza stepped in, provided financials, quote, declared that I-140 Pizza was Muy Pizza's successor-in-interest, and asserted that Mr. Nguyen's I-140 petition was eligible for job portability under INA Section 204J, end quote. And indeed, quote, under the portability provision, an I-140 petition for a beneficiary whose application for an adjustment of status has remained unadjudicated for 180 days or more remains valid if the beneficiary changes jobs or employers. Mr. Nguyen officially requested job portability soon after, and USCIS approved the request, end quote. But nevertheless, USCIS revoked that approved I-140 petition based on a finding that Muy Pizza had itself failed to prove that it could pay Mr. Nguyen's wage in 2020 and 2021. At least some of which time it appears Mr. Nguyen was with Muy Pizza, and some of which time Mr. Nguyen was with I-140. Then USCIS denied adjustment and, confusing to me given that they had just approved it, then denied his request for job portability. I guess things had changed now that the I-140 was revoked. I-140 moved to reopen and reconsider, but USCIS was unswayed. The pizza had left the oven. Which isn't even a phrase, and I promise will be the only pizza-related pun this case. So Mr. Nguyen and his family sued USCIS. And it's an interesting issue. Can I-140 assert Muy Pizza's interests, particularly where all the facts appear to be the same and line up? Unfortunately, we will not quite learn, because with so much post-Patel, the Fifth Circuit held that it lacked jurisdiction. But the Fifth Circuit did discuss some helpful things. For instance, Mr. Nguyen is right that under the text of the portability statute, quote, an I-140 petition for an individual whose application for adjustment of status has been filed and remains unadjudicated for 180 days or more shall remain valid with respect to a new job if the individual changes jobs or employers, if the new job is in the same or a similar occupational classification as the job for which the petition was filed, end quote. That's the case here. He could do portability to I-140 Pizza. The problem is that under the accompanying regulation, portability only applies if the I-140 hasn't been revoked. Here that meant that, quote, the petition was invalid from the start. And the portability provision did not apply to Mr. Nguyen's petition when it was revoked, end quote. Which to the Fifth Circuit meant that it and the district court before it lacked jurisdiction to review the issue in the first place. In a footnote, the Fifth Circuit punted a bit, as it has in the past, about whether it would have had jurisdiction to review simply the revocation of an I-140 given the portability exception. And it punted here because, as it did in the past, it seems that the petition was revoked here before the final portability decision was rendered. A bit confusing, but also pretty wonky, and something to still remember in the Fifth Circuit with litigation about such things. Nor did Mr. Nguyen's other arguments provide jurisdiction to the court. Yet the Fifth Circuit went through them anyway. It is the case, for example, that under USCIS policy manual, quote, in cases where a new beneficiary is eligible for portability under Section 204J, a successor entity need not file a new petition on the beneficiary's behalf, provided that all of the portability provisions requirements have been met, end quote. So again, I-140 should have had the chance to save Mr. Nguyen. The problem is to the court that, quote, as established, Mr. Nguyen's I-140 petition did not qualify for job portability, end quote. That is, because USCIS concluded that it was wrongly approved from the start, the I-140, quote, I-140 Pizza was therefore required to file a new or amended I-140 petition on his behalf and did not. Mr. Nguyen has not established that USCIS's failure to make a successor-in-interest determination was erroneous, end quote. It all goes back to Muy Pizza's ability to pay this wage and the legitimacy of Muy Pizza's I-140, and the fact that Muy Pizza never responded to USCIS's intent to revoke, because again, by that time, Muy Pizza was out of the game. The Fifth Circuit also rejected other similar arguments. The successor-in-interest exceptions presume a first qualified petition, which does not exist here. Interesting stuff, though, and not often discussed on the pod. That is, business immigration. Quite the deep dish of a case! You know I always lie about my pun intentions. And that is Nguyen v. Jaddou. Are you struggling to find and hire new talent that you can trust? Does the idea of onboarding, training, and managing virtual staff overwhelm you? Staffy's got your back. Staffy provides top-quality virtual staffing for immigration law firms, complete with HR support to free up your time from the hassles of onboarding, managing, and continuously training your virtual staff. With an entire team of professionals, including psychologists and mindset, task, and performance coaches, Staffy ensures your virtual staff has all the tools needed to help your law firm grow and scale. Visit staffy.cc, that's stafi.cc, and schedule a consultation to claim $500 off your first month of service. Or, of course, click on the link in the show notes. And so we conclude with Singh v. Garland, published by the Ninth Circuit on October 4th, 2024. It is yet another Singh v. Garland Mann Party India persecution case, indicative of either the number of such applicants, the treatment of such people in India at present, the commonality of names for such people, the number of denials of such claims by the immigration judges and BIA, or all of those things together, plus more. It is a 55-page single-space decision, and it's going back to the agency. Judge N. Randy Smith dissented. It's also about the BIA's 2015 decision in matter of RKK, and it's about credibility. So it's a big deal. Let's go, Mr. Singh. Like pretty much all of these cases, Mr. Singh is from the Punjab region of India, is a Sikh, and joined the Mann Party here in 2016. Quote, the Mann Party advocates for a separate state of Khalistan and for the rights of Sikhs. As a member of the Mann Party, Mr. Singh attended rallies, hung posters, engaged in community service, and participated in recruitment efforts. End quote. Mr. Singh testified to 2 attacks in 2017 while he was hanging posters. In this case, the attackers were members of the Indian National Congress Party, or the INC. As admittingly similar to some of the cases I've described before, the INC members told him to stop, to join the INC, and to deal drugs for them. Then they started hitting him with wooden sticks and similar things for about 5 minutes. Mr. Singh received medical treatment and was on bed rest for over 20 days. Then Mr. Singh went to go file a police report. And admittingly, similar to as I've described in cases like this before, he brought his father, and the police refused to file the complaint because here INC was the political party in power, and the police threatened to arrest Mr. Singh if he tried again. When the INC came looking for him, Mr. Singh fled to the US in January 2018, with the help of his father. At the conclusion of the merits hearing, the immigration judge said that there were credibility concerns given the similarity of cases that the IJ had seen in the past. The IJ requested briefing concerning matter of RKK and allowed additional documentary submissions on the issue. Spoon-feeding DHS, if I may say so myself. Then and again, post-merits hearing, quote, along with its matter of RKK brief, the government submitted 20 redacted declarations from other asylum seekers from India who alleged political persecution by the INC, the BJP, or the Shiromani Akali Dal Bandal Party, based upon their membership in a variety of different political parties, including the Indian National Lok Dal Party and the Mann Party, end quote. DHS even, quote, prepared a demonstrative chart comparing the factual allegations in Mr. Singh's affidavit to categories of allegations present in many of the other declarations, end quote. Mr. Singh responded, again, post-actual hearing testimony, and argued that he was telling the truth, and that it's not surprising that similarities would exist given what's happening in India, and that in any event his claims were distinct. The IJ was moved by DHS's submission and denied on credibility, relying on matter of RKK, which I'll get to in a sec. The BIA affirmed, but as I mentioned, a divided Ninth Circuit sent it back. It is true that the Real ID Act made it much easier for IJs to make adverse credibility findings. Indeed, that act largely targeted Ninth Circuit precedent. While not specifically addressed by the Real ID Act or any statute, quote, whether an IJ may consider notable similarities between affidavits submitted by asylum applicants in unrelated proceedings has long percolated throughout our nation's courts and immigration proceedings, end quote. But on the other hand, as the Second Circuit reasoned 17 years ago, quote, to assume that one asylum applicant is responsible for or even aware of the striking similarities that appear in an unrelated applicant's submissions is much more problematic than relying on internal inconsistencies within the same proceeding, end quote, that is to reach an adverse credibility finding. The Second Circuit then developed guidelines formalized by the BIA in matter of RKK. Boiled down, the BIA reasoned in 2015 that IJs, quote, may rely on inter-proceeding similarities as part of an adverse credibility determination, but the BIA must also review such determinations with an especially cautious eye, end quote. To make the finding one, the IJ should give the applicant meaningful notice of the similarities that are considered to be significant. 2, the IJ should give the applicant a reasonable opportunity to explain the similarities. And 3, the IJ should consider the totality of circumstances in making a credibility determination. All must be done on the record, explained the BIA in RKK. To the Ninth Circuit, though, this all really only applies where the affidavits or testimony being compared from separate proceedings involved a, quote, substantial number of instances where the same or remarkably similar language is used, end quote. Emphasis by the Ninth Circuit, but direct quote from RKK. Only a few instances might cut it too, if the facts are really unique, explained the panel. Therefore, to the Ninth Circuit, quote, matter of RKK is concerned with more than just factually similar events. It instructs that the telltale signs of a canned or plagiarized affidavit are the ways in which events are described in the affidavit, such as the use of identical phrases or words, the same grammatical mistakes and punctuation, the use of distinctive language, or the unnecessary addition of extraneous detail, end quote. Like in a First Circuit case where the second affidavit was, quote, virtually copied, end quote, from another story. Here, in contrast, explained the court, quote, the IJ did not rely on any similarities in language, grammar, or narrative structure between Mr. Singh's affidavit and any of the 20 redacted declarations submitted by the government, end quote. Rather, it was more or all about factual similarities. That was error, explained the Ninth Circuit. The government obviously needs to root out fraud in the immigration system. And strikingly similar words, phrases, or grammatical cues is one thing, but, quote, relying solely on non-unique factual similarities to deem an applicant not credible undermines a fundamental principle of asylum law, that persecution sometimes occurs through widespread or systemic actions by the government or by its acquiescence to third-party harm, end quote. Plus, explained the panel, the IJ shouldn't really have relied on DHS's chart. After all, DHS didn't say how it chose those 20 similar affidavits. Maybe it reviewed 100, and 80 were distinct from Mr. Singh's affidavit, reasoned the court. The IJ certainly didn't know if that was the case because DHS didn't tell the IJ and it was all happening after the merits hearing anyway. But that might have supported credibility if that was the case. And even the alleged similarities pointed out by DHS were simply too broad for the Ninth Circuit. Things like, quote, respondent hanging posters, respondent then approached by opposing party attempts to recruit, respondent declines, and police refuse complaint, end quote, are arbitrary and are, quote, so general as to be virtually meaningless, end quote, to the panel majority. Quote, tallying the number of check marks for these non-unique categories does not convert this process into a rigorous one. Indeed, it largely reveals its arbitrariness, end quote. In a twist that I must admit made me smirk, the Ninth Circuit footnoted 4 recent precedential wins on similar claims in the Ninth Circuit, 3 cases of which were named Singh, that would have likely fallen under the IJ and the BIA's reasoning here, thereby to the panel indicating the flawed nature of the RKK analysis committed by the IJ and the BIA in this decision. Nor did the IJ discuss the significant differences presented in Mr. Singh's affidavit. Seems important to the panel if using this type of analysis. And all of this raised due process concerns to the panel. All these 20 affidavits were redacted, so Mr. Singh had absolutely no way to combat them. Seems like such a thing would happen literally every time DHS tries this strategy, so even with more germane affidavits, keep this argument handy, practitioners. In matter of RKK, after all, the 2 declarants were brothers known to one another, and that was similar in other circuit cases. So that's actually a massive holding to undermine matter of RKK and DHS's strategy of presenting like affidavits. Quote, the agency's reliance on the redacted declarations did not afford Mr. Singh a meaningful opportunity to offer reasonable explanation or credible evidence to dispel doubts about the authenticity or reliability of the initial evidence, end quote. Which again will always be the case because those affidavits that DHS is submitting will always be redacted, right? And heck, in a footnote, the Ninth Circuit also says that the IJ erred in other adverse credibility rationales as well. The panel goes on to tangle with the dissent about matter of RKK and matters of issue exhaustion, and then additionally held that the IJ and BIA erred in finding that Mr. Singh could relocate in India to avoid the harm he fears. Again, told you it was a long one. Assumed credible, Mr. Singh established past persecution, it seems, and the panel doesn't see DHS as having met its burden on relocation. India's big, but there wasn't evidence, for example, that Mr. Singh actually lived outside Punjab safely, rather than simply passing through, or that he was engaged in Mann Party activities when he did. Seems like the Ninth Circuit is saying that individuals need not give up their political activities to be safe and qualify for asylum, just as many circuits have said that individuals need not hide their religion. First Amendment for life. And it also doesn't matter that Mr. Singh is a low-level Mann Party operative, either. Continuing on, just because the Department of State report does not mention violence against Sikhs says very little to the panel, not least of which about the danger to Mann Party operatives. The absence of evidence is not evidence to the panel. Rather, it's IJ speculation, explained the court. Quote, an omission in the State Department report about acts of persecution does not support the inference that this form of persecution is rare or non-existent, end quote. You'll be seeing that guy on the podcast's social media pages, I promise ye. Anyway, DHS didn't carry its relocation burden. Quote, at best, the record presents equivocal evidence concerning the safety of Mann Party members to practice freely in other areas of the country, end quote. Insufficient when DHS has the burden. So congratulations, Alexandra K. Jacobs and Jagbir S. Turkiana for petitioner. And yeah, massive case. Cannot do the 25-page dissent, but I bet we'll see another one of these soon, where a judge who agrees with Judge Smith, or even Judge Smith, is in the majority. Such is litigation on contentious, reoccurring issues. Final thoughts. I know some people are a bit suspicious of these cases. Certainly the IJ and the BIA were here. And who knows, maybe some people are not being honest. But to me, the whole RKK similar affidavit thing should be approached with caution. Something the Ninth Circuit majority is saying here as well, and even the BIA said in RKK. After all, I imagine, for example, that, if 5,000 Cambodians were fleeing the Khmer Rouge to America in 1977, and if all of them applied for asylum under the current framework and ended up in immigration court, they'd all have pretty similar stories and would use similar resources to create their affidavits that would then also appear similar. It wouldn't make them not true, though, given the fact that the Khmer Rouge, in this hypothetical case, is believed to have murdered or led to the murder of about 25% of Cambodia's population, or like 2 million people. So just keep it in mind. Or as the Ninth Circuit put it here, quote, that multiple asylum applicants from the same region of India might describe similar forms of persecution does not necessarily imply their accounts are false and should be discredited, end quote. It could just be true and a massive, horrific problem. And that is Singh v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.